Morning. Good afternoon.
Good afternoon. I've opened everything all at once here. Somehow we have 1, 2, 3, 4 things all set at 1:15. And I'm going to bring a couple more people in here. This is Judge Middleton. I'm here at the courthouse in Centerville. You're all here for landlord tenant matters. Thank you for being here. We do have 4 things set at 1:15 and 1 at 1:25. I'm not really sure how that happened. But we're going to start with Enchanted Glen and Montaigne, and then we'll work on the others. Mr. Knopfsinger, which case are you here on?
For Mr. Nichols.
Oh, okay.
Lindsay Pantoya.
All right. Well, let's start with Enchanted Glen versus Montaigne. April was here. I had her in the waiting room and I lost her.
I believe I see her, Your Honor, on the Zoom.
I'm here.
Oh, there you are, April. Very good. Thank you. She was early. I had trouble with setting things up here, having struggles. Live chat feature. And then I've got a phone number. Who am I speaking with?
This is Christine Walker.
All right. Which case are you here on?
It's Blue Stream Capital.
Okay, you're in the right place. You're a little, well, you're in the right place. So let me just give you a name. Somehow these things got set like they used to be set, and they were all set at the same time. They're supposed to be set at about 10-minute intervals, but let's start with what we got. Enchanted Glen versus Montaigne. This is file 201692LT. Ms. Brianna Kingley is here on behalf of Payless Law for Enchanted Glen.
Good afternoon,
David,
Your Honor.
Good afternoon. Of the Hass Kaywood firm is here from Sturgis. Pretty soon they'll call it Hughes, Hass, and Kaywood. But
I don't know about that.
the defendant who is present. This case has got some miles on it. It's a tough one. It's a termination of tenancy. Defendant doesn't want to, well, she does want to move. She can't find a place to move to, and there's a jury demand in here. What we have set for today is plaintiff's response to defendant's request to compel discovery. And frankly, I'm not even sure what the exact posture of this is. I'll start with you, Ms. Kingsley, and anything that you think I should be aware of?
Your Honor, it's our intention to file a motion for summary disposition in this case, so I really need the documentation from Mr. Hughes in order to proceed on that. And that's about it.
All right, Mr. Hughes, what's your response?
I contacted Ms. Kingsley earlier today and agreed to stipulate to provide all the documents within 7 days. She felt we should bring it before the court, though, to present the stipulation. So I don't think there's any disagreement here as to the relief sought.
All right, very good. April and I were talking with each other last week in a somewhat related but unrelated personal protection order case. And she indicated at that time she was actively seeking to move. April, any other success with that?
No, I've left a bunch of messages. I right now I don't have service on my phone, so good thing I have Wi-Fi, but I'm waiting for people to call me back. I called like a bunch of landlords over in Cold
All right,
Island.
well, that's enough. You just don't have any hot iron in the fire. So
No,
we're still
not at all.
now.
No.
Mr. Hughes will explain what a motion for summary disposition is, but it's a motion to essentially say there's no material issue of fact. As I'm sitting here, I don't know that I've ever had a summary disposition motion in a landlord tenant case. I can't recall one. but I guess there isn't any reason why we couldn't have it. So, defendant will forward discovery within 7 days. Ms. Kingsley, how long do you need to file your motion for summary disposition?
Your Honor, if I could have 3 weeks, it's about finalized. I just need to look over the documentation. Also, I'd like to note that in my motion to compel discovery, I did request that if opposing counsel does not turn over the documents within 7 days, that a judgment of possession should enter.
You agree to that, David?
I guess I would agree to, we will respond to their discovery response within 7 days. There may be they feel our answers are incomplete, or that they feel we haven't provided something that my
They
client
can request, all right, then they can request possession. If discovery is incomplete, plaintiff can request hearing regarding possession.
Thank you,
Your Honor.
Yeah.
All right, April, keep looking. Maybe that'll solve this. All right, anything further we should place on the record here?
Your Honor, should I call the court to obtain a hearing date for the motion?
That'd be fine, or I can give you one right now if you'd like.
Sure.
Well, he may need some time to respond to it. How much time do you need to respond?
Well, I think under the court rules, it's got to be set for hearing 21 days after filing. So
Yes, so it'll go ahead and file it and we'll set a date.
Thank you, Your Honor.
All right. All right, thank you. We're going to move on to our other business here this morning. Thank you for this
Thank you,
Thank you,
afternoon.
Judge.
Thank you. See you again. April, good luck. All right.
Thank you, Your Honor.
Her. All right, next, let's take up Blue Strain versus Kelly. Kevin Kelly is here, and Christine Volkert is here. I spelled Christine wrong. Mr. Kelly's right here at the conference room. Let me correct the spelling of her name. Good afternoon, Bettina.
Good afternoon, Your Honor.
This is file number 21771 SP. It's a land contract forfeiture action. Mr. Neil Jansen is here on behalf of the plaintiff, Blue Street Criminal, or Blue Street Capital from Grand Rapids, or Caledonia. Mr. Jansen is appearing from downtown Grand Rapids. Kevin Kelly is here on the conference room. Mr. Kelly, can you hear me?
Yes, I can.
Christine Volkert is connected by telephone only. This is filed as a land contract forfeiture action, and as such, I need to advise you of your rights in a landlord tenant action.
Okay.
I've also got Nicole Roy here, and I'm not sure which case she's here on. But let me tell you of your rights. As a defendant in a landlord tenant proceeding, including non-payment of rent, termination of tenancy, land contract forfeiture, which is what this is, or other actions, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, which this is not, you could be eligible for some emergency housing assistance. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can facilitate that. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. This is a land contract for a piece of property in the village of Constantine. I'm getting the gist that perhaps, are you both still in the property?
Yes.
Yes.
Sir.
All right.
Hello?
Yes, I'm still here.
Okay, sorry, it went quiet. I wasn't sure if it
Well,
disconnected or
you
something.
You don't have a camera. I'm deep in thought here. I'm just making some notes so I can resurrect this if I need to in the future. The law says you have a right to an adjournment of at least 7 days after the initial hearing. Your landlord or the person that holds the land contract contends that the land contract is substantially in arrears. $24,000 in arrears, and no payment has been made since January 4th. I'm not sure if there was January.
I thought it said 2,400 is what I saw.
It says 22,000. Let's take a look here. Yeah.
Oh, that's for the remainder of the contract. Okay.
And taxes
That's like-
of 2804.59 and insurance 962. Is this a balloon contract, Mr. Jansen? Is the balloon payment up?
Yes, Your Honor. And
No, it's not up to October, I thought.
the, looking at the contract. Well, actually, that's correct, Your Honor. We have a land contract. I'd like to file with the court when we can, a different land contract than these Volkart signed, other than one we sent. It does give her to October 5, 2021. So she's only in arrears as to the monthly payment she's missed since January.
All right, so the pleadings are not correct.
Correct.
Shows she owes the whole balance and she doesn't.
Right. So we need
I
to
can't
amend- I'll need to amend that complaint, Your Honor, if I could.
All right, I'm going to adjourn this 2 weeks and give you 7 days to amend the complaint. I told her that the whole thing was due, and that apparently isn't accurate. 7 days to file. How much is the monthly payment? Let's take a look here.
375.
I agree, Your Honor. That's what the contract reads.
What's that? I'm sorry.
I'm trying to,
Oh,
the print's kind of small in this copy that I have. All right, so it appears, rather than having the entire balance due, you owe about 6 months worth at 375, plus these other issues, taxes and insurance. But I can't
which
tell
are
you how
part,
much.
the taxes and insurance are rolled in with the 375 a month.
Okay.
That's how it's always been. So I don't know how that would be like extra. Maybe I don't understand.
Well, the whole thing is wrong, so he's going to correct it. And
Okay.
rather than have you served all over again and start all over again, who's actually living in the property?
Myself, Kevin, our 2 children, they're 8 and 6.
Well, I've got a Union Road address for you in
Yeah.
Jones.
That
What
was
is
where
that?
we lived when we moved here.
Okay, but
That
the
was-
whole family's residing at 240 South Washington?
Yeah, that's when we moved here to Constantine. Before that, we lived in Union, or on Union Road in Jones.
All right. Well, I don't know how much you do owe, so he's gonna file an amended complaint, and we're gonna take another crack at this in 2 weeks. So today is June 14th. Let's continue this to June 28th at 2 p.m. Be by Zoom like this once again. Mr. Kelly, do you have any questions?
Nope.
All right, I don't know how much you owe. The contract is in here. I didn't fly spec it. I simply looked at it and I assumed it was a balloon contract and the whole thing was due. It's apparently not accurate. So there are some months due at $375 per month. I'm not clear whether that carries taxes and insurance or not. We'll see what the amended complaint says, and we will try again 2 weeks from today at 2 p.m. You do have the right, as I told you, to seek legal advice, and I encourage you to do that.
Okay.
But let's see where we are. Perhaps there'll be a clearer picture of this. Let's assume that they get what they want, and they say that you're 375 times 6. That would be, give or take, 2250. You would have 90 days to redeem the land contract. I'm assuming there's less than 50% paid. So there would be time for you to get squared away, but we'll talk about that further in 2 weeks.
Okay.
Mr. Jansen, anything further we should put on the record here?
Not at this time. Thank you, Your Honor.
All right, thank you. We'll take another look at this. All right, thank you. You're all good to go.
Thank you.
Okay. Thank you.
Thank you. All right, next up is Memory Lanes Mobile Home Park versus Rhodes. That would be Mr. John Bush. That one kind of took a left turn there.
Hi, Mom.
All right, this is file 21429LT. It's entitled Memory Lane Mobile Home Park versus Donald Rhodes and Nicole Roy. We were here way back on April 29th. Chris Corpening was here. The defendant had applied for assistance through Keystone. We were here again on June 7th. Apparently some assistance had been approved. Mr. Rhodes is not here. Miss Roy is. Miss Roy, can you hear me?
Yes.
And our housing advocate, Bettina, is here also. Bettina, what can you tell me about the emergency assistance?
They've been approved for $7,521. Their payment will be processed by the end of this week, and checks should be mailed out by next week.
Well, we adjourned it last week for the very same reason. They haven't been able to get the checks out.
No, Your Honor.
John, what do you want to do? If we adjourn it again till next Monday, we're going to be in the same boat.
Well, I hate to do anything till the check's in hand. I guess I'm old fashioned.
Yes.
I mean,
Well, let's adjourn this 2 weeks. That's why I put 115 on this one. I assumed it would be paid and we'd just be to dismissal. All right, checks in the mail. Continue to 6/28/21 at 1:15. Bettina, does that pay through July?
It covers for the next 3 months.
June, July, and August.
Yes, Your Honor.
All right, very good.
and obviously if the check comes before that, we can probably start the paperwork to take care of it. Then.
Dismissal. Miss Roy?
Yes.
This system is supposed to work to help people get their rent paid and not be evicted and help the landlords get their money. The problem is there are so many people that are applying for assistance right now, it takes a while to process all the checks. But you've held up your end of the deal. You've completed the application, you've provided all the information needed, and you're entitled to relief. You're going to get your rent paid June, July, and August, which is a blessing for you and your landlord. However, we haven't got the check yet, so I've continued this for 2 weeks at 1:15. If the check comes and is cleared, Mr. Bush will dismiss the case. If not, it's your obligation to be there 2 weeks from today, okay?
Okay.
Do you have any questions?
No, Your Honor.
All right, you're good to go. Thank you, John.
Thank you, Judge.
Thank
All right, our next case is Shane Nichols versus Lindsay Pantoja. This is file 21653. We were here last time, way back in May 14th of 21. At that time, Luke Knopfsinger was here, Mr. Nichols, and we found that the case was closed. We found there was an arrearage of $4,500 plus costs. We continued it for 30 days to June 14th. Keystone was going to attempt to reopen the file regarding assistance. Bettina, what can you tell us about this one?
Mrs. Pantoja has been in contact with us. It took us a while to get some documents that we needed from her, but she did end up sending those in, and she currently is in processing.
We used to have a 7-day adjournment. Now we do a 30-day adjournment, and that still doesn't appear to be enough time. Luke, what's your preference here?
Well, yeah, Mr. Nichols and myself had talked about this possibility, and he's been in cooperation, I think, as late as Friday about providing a ledger. I mean, we certainly want to take advantage of the assistance. Maybe it's an unfair question to Bettina, but how long would it take?
That's the $1 million question that everyone wants to know. I mean, and I wish I could give that answer, but I don't have a time frame.
And also, she's not here. I don't know why she's not at her own hearing.
Yeah, concerning. 2 weeks, is that?
All right, I'm willing to do that if you are, Mr. Nichols. There is the possibility you'll get your rent paid, which is a win-win. You get your money, she gets her money. Rent's continued, and we struggle a little further till people can get employed. All right, so is that agreeable to you?
Yes, sir.
All right, let's continue this. And if she isn't here next time, I'm going to default her. 6/28, going to be a busy day at 1:30 p.m. To await Keystone processing.
Your Honor, would it be possible to move that to 2 o'clock?
Sure.
Thank you.
I'll be here till midnight, so that'll work. All right, Mr. Nichols, thank you for your patience. Let's hope you can get paid. She can get her rent paid, and we can get through the summer. If not, she's subject to being evicted on the 28th of June. All right, thank you. You're free to go.
Thank you, sir.
Thank you. I'll move Mr. Nichols. And Miss Lindsay is here. She's a little early. This one isn't set. No, it's set for 1:25. So. Good morning, Mary, or good afternoon, Mary. Can you hear me? You need to unmute your mic.
There we go.
Thank you. Good afternoon. Oops. Oh, cancel that one. This is file 21721LT. Block 14 Inc. versus Mary Lindsay. Mr. Jeremy Gump is here on behalf of Block 14, and Mary Lindsay is here on her own behalf. This is the most difficult type of case that I have. It's a termination of tenancy, or the tenant hasn't necessarily done anything wrong, but the lease has expired. Your lease expired in April, and the landlord wants you to move. So, Mary, I need to advise you of your rights as a tenant in a landlord-tenant proceeding. I did this a few minutes ago, but you were still in the waiting room. So let me tell you this. As a tenant in a landlord-tenant proceeding, including a termination of tenancy, which is what this is, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services could be available to help you. But this is not a non-payment of rent case, like some of the ones we just did. If the plaintiff is agreeable, Citizens Mediation Services, Inc. may be available as a source of case resolution. If the parties are agreeable, the court can help facilitate that. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above, but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. I think you and I talked a while back, and your plan was maybe to move. What's your current status here, Miss Lindsay?
I have literally been trying to find a place to move since December. I mean, I've applied a bunch of places. I mean, I've just went out and drove around trying to, find some place to rent, and that's.
Well, I don't disbelieve you, Mary. I hear this every week. I had several cases today where the people said we would leave if we had somewhere to go to. One lady told she called dozens and dozens of places. I thought you were also thinking about maybe moving out of state or something, but I don't know. We don't have to get into that. But I trust what you're telling me because I hear it all the time, and I don't have a reason to not believe you. The problem is, apparently they want you back. I have one case where the landlord wants to sell the house. Someone wants to buy it and move into it, and they can't get the tenant out for more than a year. I'm not sure what's behind this, but your lease is up. The law requires that I set this for a second hearing at least 7 days from today. So let's see what we got on the calendar. Kick me out of my own calendar. We have next Monday, June 21st, or we have Friday, June 25th. 21st would be in the afternoon. 25th would be in the morning. Mr. Gump, do you have a preference?
The afternoon of the 21st.
All right.
Your Honor.
June 21, 21 at 2 p.m. Mary, we're going to continue this for 1 week for your opportunity to get some legal representation or find another place to move to. We had a couple of very unpleasant evictions this weekend where the sheriff was out putting people out of their houses. The police got called on one several times, and I understand it was very unpleasant. But he came between the proverbial rock and the hard place. The landlord wanted the property back, and the tenant didn't have anywhere to go. And there was an eviction, which is what we tried to avoid.
Right. And I mean, it's just going to be, living in a hotel pretty much is going to have to be until I find a place to live. So.
Well, now let's talk about this. We're going to reconvene next Monday at 2 o'clock. If they get what they asked for, I would give you 10 additional days. Next Monday would be the 21st, and I would give you to June 31st, which doesn't exist, be July 1st. Someone just made that gaffe. When I was a kid, there was an Encyclopedia Brown mystery story that was hinged on the fact somebody wrote June 31st on something. But anyway, 10 days from next Monday would be July 1st. Then they could evict you, or they could have 56 more days to 46 more days before they decided to serve it. I know you've been trying to move there for some time, and I don't have a better answer. I mean, you may have some defense, which I'm not aware of, which you can discuss with an attorney, but you're not going to get put out on the street next Monday. They have a minimum of 10 days and potentially as many as 56. But you should be prepared to be moving by the end of June, first day of July. All right, I'll see you next week. Do you have any questions?
No, I don't.
All right, Mr. Gump, anything further?
No, Your Honor. Thank you.
All right, we'll see you next Monday, June 21st at 2 p.m. Thank you.
Thank you.
Thank you.
All right, Bettina, I think that's all I've got for you. I have a damage hearing at 2. I have a couple of civil motions. Gotta remove this. And they don't involve you. So if somebody comes in with an emergency, I'll send you an email, but the damage hearing is for some pretty substantial damages. Meantime, I have 2 summary disposition motions to deal with. All right, thank you.
All right, thank you.
Wait a minute, here's Mr. Fleeman. I'm not sure what he's here on.
Okay.
Good afternoon.
Good afternoon, Mr. Fleeman. Oh, you're here on HZ-CNAC.
Yes, I am.
Okay, I thought you were here on a missing landlord tenant case. All right, Bettina, you're good to go. Thanks.
Thank you.
I have Andrew of Rognus. He's not till 2. And then I have a telephone number. Let's see who this is. Good afternoon. I have somebody here by telephone. Who am I speaking with?
Ashley Longacre.
All right.
Hey Ty, how you doing?
He's doing fine. I'm going to mute your mic. You can sit there and contemplate your place in the universe.
I was just looking, Judge, I don't seem to have the motion on this file. I don't know why. I have the notice of a motion, but I don't have an actual motion.
Well, let's see what we got.
Right?
I'm not sure there is an actual motion.
That may be why I don't have it.
This is file 214GC. This is HZ-CNAC Inc. versus Ashley Longacre. A default judgment entered by Judge Pattison when I was on vacation in April. for a lot of money. $12,393 plus costs for a total of $12,729. Ms. Longacre did not appear for the hearing and a default judgment was entered. We had a hearing on April 5th and I made a finding to that effect, joint and several with Joe Wilson. Joe Wilson hasn't filed anything, but for some reason it took a few days for the thing to get here, and Judge Pattison signed it on my behalf on April 12th. Ashley Longacre wrote a letter to the court, received May 13th. And I'm not sure. It was not received within 10 days of the receipt of the judgment. Judgment was entered April 23rd. Defendant filed her response. Well, maybe that was, no, it wasn't filed within 10 days. Anyway, so hopefully do you have a copy of that letter dated May 6th?
No, sir, I do not.
Well, that's a screw up on our part.
Yeah, but let me double check here. I have the notice to appear and the remote participation hearing, but I don't have anything else attached to that.
Well, that's our error. I apologize. There are multiple problems with Ms. Longacre's filing. A, it wasn't filed within 10 days of the entry of the default. B, it doesn't set forth any meritorious defense. And C, she doesn't present any good reason for missing the court date. And it applies to only her. I'm sorry for not attending my last court date. I really don't want to write down excuses. I didn't realize I had a court date. So, Ms. Longacre, there are several problems here. What else do you want to tell me?
About the money owed, or?
Yes. Well, first of all, why didn't you show up for court?
Well, I've had a problem with my mail. I didn't even get my W-2 because the neighbor boy has been in my mail. So I didn't even realize I had a court date. I never miss court. I've never missed court a day in my life. So, but I had to talk with his mom because I noticed some pieces of my mail in his yard. So I don't know what happened to it, if something happened to it. So I don't know. That's why I had ended up calling the court to see what was going on, to see why I haven't heard anything, and they had told me. So that's why I wrote the letter. And here we are.
This case is all messed up. First, I made the finding. Judge Pattison signed the order on my behalf. It took a while to get the order out. It was signed on we already had a default. Then we had a default originally on March 2nd that I signed in that amount. Then, for reasons like, wait a minute, that's against Joe only, I think. Yeah, against Joe Wilson only. So he's still liable. Then they had some trouble serving Ashley. We set that hearing for April 5th. It didn't get signed until quite a bit later. And then you filed your motion. And then we didn't send a copy of your letter to the plaintiff. A, you're supposed to do that, but you didn't know it. And B, then we never sent it to them. So that's a source of embarrassment for me. So, Mr. Fleeman, you're in a position of trying to argue against something you haven't seen. Although there are multiple problems with it. What's your response?
Well, I don't think that she's set forth a meritorious defense, at least not from it sounds like in the letter that you are looking at, that she set forth any meritorious defense. I was going back to the original answer, and I haven't found that just yet. But in any event, I think that the default judgment is probably appropriate because she missed the hearing and didn't set forth a meritorious defense. Oh, there it is.
The January letter?
No. Oh, yeah, January 27, 2021. Is that that's what we're calling the answer, right?
That's what we've accepted as an answer.
I understand. Okay. And this is a common thing that I hear with people relative to, these types of vehicles. These are inherently used vehicles, oftentimes have fairly high mileage on them, and that there are difficulties getting it fixed is a fact of life, not a defense. Any of us that have
they're sold as is that correct?
Right, that's right. In fact, I don't see any warranty on this. I'm looking back through the purchase agreement. I don't believe there's a warranty. Miss Longacre, did you pay for a warranty?
I was under the impression that it did have a warranty. I had actually been stranded in it like over 30 times and had called them to come pick it up. And they gave me a problem every time to come fix it because they said I had a 24,000 miles for a warranty, and I was still in the mileage range. So, and it just wouldn't even get to point A to point B. I missed several days of work, and they just were not cooperative with me at all.
Well, it sounds like you said you had over 20-some thousand miles on it. Is that what?
How many?
Well, you mentioned something about the fact that you had X number of miles on the vehicle, and that they were telling you that took you outside of a warranty.
No, she contends she was inside the warranty. I can't tell whether there is a warranty, and there's an exhibit sticker over the mileage, so I can't tell what the mileage was on this vehicle.
The exhibit sticker covers it? Oh, no. Oh, I see. Judge, I think I have another copy of that. Yeah, the copy I have has it. It just has the sticker over the top of it. So I think I sent the original in. Hang on a second, though. I got another document that'll have that. Well, I see that it was a 2007. So it was sold in 2016. So at that point, it's what, a 9-year-old vehicle?
Yes.
They give me a ton of information, and I'm sure that within this ton of information, I have the mileage.
Well, I guess that isn't as important as whether or not there's a warranty. There's no normally they say sold as is with no
Right.
warranty.
Right.
And they don't sell 9-year-old cars generally with a warranty.
Right.
There's a lot of money for this car. The car was $13,186, and the finance charge was $9,008. So the total charge then became $24,000 for a $13,000 car. It was 9 years old. Normally they're sold as is, but I can't tell whether there is or is not a warranty. Let's see if she mentions that in her original pleadings. They say I have a warranty, but gave me a hard time to fix it. Every time they fixed it, it broke down the next week. So that's very common. These old cars break, but I don't know whether there's a warranty or not. And so, Miss Longacre, I talk to people like you all the time. You claim predatory lending. Nobody put a gun to your head and made you pay $24,000 for this 2007 Ford Explorer. People don't have good credit. They have other issues. They need a car. They go to aftermarket car sellers like this, and the contracts are very expensive. The interest is high, and the cars often break down. But those car sellers are saying we're providing a service. No one else would lend these people any money and they wouldn't be able to buy a car. If it wasn't for us, they wouldn't get any transportation. And there's enough of them and people keep going to them, so it must be a needed service. But you got multiple problems. You don't have to prove there is a warranty. It would help if you did, other than just pled it. They haven't proved that there isn't. But there's multiple problems. The default judgment entered, and you have 10 days to move to set aside the default. More than 10 days had passed before you filed an objection. So that's problem number one. Number two, you've got some vague idea that someone took your mail. I'm not sure. I don't find a valid reason for not appearing for the hearing. You got everything else that was sent to you. And three, I don't know whether you said a meritorious defense, because I don't know whether there's a warranty or not. There's already a default against Joe Wilson, the co-borrower. Mr. Fleeman, what can you tell me about a warranty?
Well, Your Honor, I have been flipping through my documents and I do not see anything indicating that there was a warranty. I see that there was a service contract on page 2 of the deal, but that I believe is for servicing the vehicle, not a warranty that it won't break down. Though it does speak of 36 months, 36,000 miles. I would suspect that when I reach out to my client, there's more documentation that goes with that. I'm just pulling this from the original deal.
All right, well, let's continue this. Miss Longacre, do you have any copy of this warranty that you're discussing?
I had honestly lost everything in that relationship when I left it. I can go through some boxes I have and see if it's in there. I mean, that's the most I can do, is see if I still have it. But I had lost everything in that relationship, so if I could I'll look, see if I have it.
All right, well, there's one big problem is you didn't move to set aside the default within 10 days of when it entered. I ought to just put a bullet in this right now. And secondly, you haven't given a good reason for not appearing. I don't know whether you have a meritorious defense. If there's no warranty, you don't have any meritorious defense. It's just you bought a junky car at a high price and it broke. And then the cars get repossessed and the people owe almost as much as they would have paid for the car. I really do not like being the enforcer for these contracts. If I had my way, I would refuse to do it. But they're legal contracts and people sign them and I can't just decide, well, I don't think I like that. I'm not doing it. The law says I have to follow the law. And these contracts have been challenged over and over again. And as far as I can tell, they withstood the challenge. It's a risky borrow and a risky lend.
Your Honor?
Yes?
I feel I have a duty of candor to the court, and that under MCR 2.603, the defendant has 21 days after the default judgment to file.
Oh, yeah, that is correct, not 10.
You're thinking
so when
landlord
I
tenant.
count, you are right, it's 21 days. And when I said to set it, look at my note. 10 days is a different standard, the landlord tenant matter. She got it on the 26th and she filed it on the 23rd, so it was within 21 days of the motion to set aside the default. You're correct. And that's the way
I think I
that's
would
why I allowed
ask
it in the first place.
what I would think would be the smart answer here is why don't we adjourn this motion for a period of time, and I will circle around to CNAC and find out what I can get relative to the warranty question, and usually they'll be able to give me other information as far as miles driven and calls for service and things like that. So why don't we
adjourn this until July 6th?
Do you know what time that would be? 7-6?
Well, wait a minute, that won't work. That's a Tuesday. And we'll be extremely busy that day. And I'll be gone July 12th and 13th. Oh boy, let's go to June 28th, which is already packed.
June 28th.
Let me look at that date.
I've got, on the 28th, I'm good in the afternoon.
All right, let's take a look. 2 p.m.
Okay.
And I will make sure the staff forwards you a copy of her pleading.
Thank you. And, Miss Longacre, what is a good number to reach you?
Hold it. I don't want you to put that out over the live stream feed. So,
you're right. I thought you would stop streaming, Judge.
Well, that's a long story. No, we're streaming now.
Okay.
Let me see if I've got one. Ms. Longacre, I want you to contact the court with your number, and then we'll give it to Mr. Fleeman.
Okay.
And Ms. Longacre, if you could provide an email address also, if I get some documentation that bears on this, I'll try to get it emailed over to you.
Okay.
All right, Judge, June 28th at 2 o'clock. Right.
Yes, thank you.
All right. I'll get that on the schedule. Thank you, sir, and you have a good day now.
All right, I'm sorry for the confusion.
Oh, no.
Ms. Longacre, we'll see what we can figure out. Do you know where Joe Wilson is?
He moves around several places. He just moved again, so I could.
Anything they collect from him.
I'll get his address.
To the step. All right, provide that to the court also. Thank you.
Okay.
All right, thank you.
You're welcome. Thank you.
Thank you. Mr.
Have a good
Freeman,
day,
thank
Andy.
you. All right, now we've got Jessica Burgess. And we've got, who's this? I've got a,
That's probably Terry Richmond.
Yes, I'm on the line.
all right, stay right where you are for just a moment. This also, I have a motion for summary disposition in Discover Bank versus Kevin Bushhouse, which is set for 145. No one is here for either side, so I'm thinking perhaps there was a resolution of that matter. And that's a blessing because we're way behind schedule. All right, Ms. Burgess, we're sorry to wake you up from your afternoon nap there, but we have some business we got to transact here. Let me give Mr. Richmond a name. I gave him a hard time the first time we met because I thought it was not who he was, but it's the other Terry Richmond. All right, this is a damage hearing. It's entitled Terry Richmond versus Jessica Burgess and Joseph Burgeon and any others for a property out on Boone Road. We had a hearing earlier and for a non-payment of rent. Keystone was going to be involved, and I'm not sure what happened. And then this matter was continued for non-payment of rent. I excused Bettina, and in fact, I still need her. I was thinking this was damages.
Your Honor, if I may, I'm not certain that Keystone's going to do anything. If you read the memorandum of law, this is the property that was damaged by fire.
Yes.
Yes,
my recollection is
they
that,
won't help because there's no home, a livable home on the property.
yes. All right, but there's a bunch of unpaid rent. All right, Mr. Richmond, wherever you are, I can't see you, but I'll trust that you'll raise your right hand. Ms. Burgess,
Yes.
will you raise your right hand, please? You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes.
All right.
Yes.
At the time of filing, the plaintiff alleged that the rent was $650 per month. It was last paid partial in October. So through May, the allegation is there was $5,650 worth of unpaid rent. When did the house burn?
February 23rd, 2021.
Do you agree, Ms. Burgess, that the rent was $650 per month?
Yes.
May I step in, please?
Not yet.
Okay.
you're not here, you can't see me, and you've got a lawyer, so your lawyer speaks on your behalf, and you don't just shout from the seats. I'll give you a chance to speak at some point. So, Ms. Burgess, do you acknowledge that rent was last paid on October 15th?
Yes. Yes, sir.
All right, I hear you. Andy,
Sorry.
so does that pay through October, or you're counting half of October?
Well, I'm running to the 15th, so I added June because our writ date's gonna be the 24th. So you gotta take that 5,650 and add another 650. That makes it a flat 6,300.
Well, you're charging a rent for a burned out house she can't live in?
Well, like we indicated in that memorandum law, she's the one that's in constructive possession of that. We can't take possession of that property. She's left her property behind there, and her husband let his baby mama move in there. There's people on that property. We can't do anything with it.
There's absolutely nobody on that property.
At this point.
Same thing for you, Miss Burgess. I'll give you a chance to speak.
And the worst case scenario is Mr. Richmond's getting pressure from the township to do something about it. And the insurance company says, we're not going to give you proceeds to do the demo until you get people out of there. So they pretty much
All right.
put Mr. Richmond.
Let me ask this, Miss Burgess. Do you have any objection to them taking immediate possession?
My landlord has told me that he would sell me the property for $35,000. Now, the home was burnt down, yes. The home was actually burnt down from faulty wiring in the home. My landlord, I had over 3 electricians come out. They never finished the job. My landlord knew that. My electric went skyrocketed since back in August. It started skyrocketing. I have all of my electric bills right here with me, stating my electric bill is $100.
All right, you
my
didn't answer
house
my
burns
question.
down.
If it's a burned out house, I guess the number I use doesn't matter. Because you're not going to pay it anyway, and it'd be determined at a damage hearing. But it certainly appears, I'm just going to go with standard order. Andy, you sent me a judgment.
Yes, I
So
did.
if we add another 650 for June,
That makes 63,000.
6,300
That could be
plus 199.20
Okay. And
is
199.20 cost.
199.20. All right, Mr. Joseph Burgess is not here.
No.
I'm going to do an order for possession within 10 days. I'm not going to show as a default as to Joseph.
I'm sorry?
Joseph got defaulted. He's not here. But
What does that mean?
It means he's going to get the same thing that you are.
Okay. Now, how would I be able to
Hold
keep the house for longer?
You can't unless you pay $6,300.
Okay, well, the last time that we just had gone to court, you told me that I didn't have to pay for a burnt down house.
You don't.
And
So
the
my
reason why I
suggestion-
hadn't paid rent.
I'm not ordering
that
I'm not ordering that you pay this rent. This house burned down. He doesn't want to sell it to you. He wants to get whoever's there off of it. So I accepted Mr. Rognus's argument that it's a constructive possession and people are still there and they can't sell it or tear it down because somebody's in it.
There's absolutely nobody that's been on the property. Nobody has been on the property. I mean, I go there and I clean it up. I make it look good because I've been wanting to buy it from Terry. Terry knows this. He's aware of it.
If he's willing to sell it to you, more power to him. Otherwise, you got to pay the rent. But I would advise you to not pay the rent for a burned up house. And
Right.
the fact that you want to buy this burnt house is different than the fact that you have a lease. I'm not ordering that you pay this amount of money. I'm ordering that you pay this amount of money if you wish to stay there. And if you want to, but if he wants to sell it to you, I guess he can choose to do that. But you also have 10 days. So that gives you 10 days from today, which is June 24th.
Can I claim destructive eviction?
I guess you could. I went through your rights with you back a month ago. We're now a month later. You don't have an attorney here and you haven't filed any sort of pleadings. It's a burned out house. You're not living in there. You're not paying any rent. He wants his house back. He doesn't want to sell it to you. He just wants it back. So
Well, he keeps on telling me, he keeps on giving me the impression that he will sell it to me. But
well, if that's between you and him, if he wants to sell it to you, more power to you. But at this point, I would not recommend that you pay any rent toward this inhabitable burned up house. Sure, have been a lot of fires out on Boone Road. I can think of at least 2 other cases where we were dealing with burned houses there, and there are not even very many houses on it. Anyway, Ms. Burgess, this is, a rough situation. Where are you staying right now?
I'm currently living with my mother that's going through a really bad divorce right now. It's a really ugly divorce. I have 5 children. That's why I'm trying to acquire the property.
Well, it seems to me you could do better than buy a burned out house for $35,000. But if he agrees to sell it to you, that's fine. But at this point, no one's there. There is a lease. No one's paying anything. He argues that you still have constructive eviction. He can't demolish it because you and your ex are on the lease. And he's stuck. So he wants you to either, now the irony is if you pay the rent for this burned out piece of property, then your rights continue. I would not encourage you to do that, but if you did, then you would have occupancy for the rest of your lease period. The other thing is if you can discuss it with each other and he agrees to sell it to you, well, that's okay too. Now, Mr. Richmond, I cut you off when you wanted to tell me something. Now is your turn. What else you wish me to know?
Thank you. The rent was not monthly. They had converted to a weekly rent back, I don't, the date of the weekly
December
conversion.
17th, or December 15th, 2017.
All right, well, same thing. You can't just blurt something out. So
sorry.
Just wait.
Thank you for that. She was current to 8/14 or 8/7 of 20. She was to the date of the fire 28 weeks, 4 days behind. From the 8/7 to 2/23, her total rent before the fire past due was $4,285.71.
All right, well, all right, let me stop.
And I did not.
Let me stop you
I'm
here.
sorry. Okay.
She says she's discussed buying the property from you. What's the status of that?
It isn't going to happen. She can't. She has no place that she can live there. No one will finance a property without a house. And I'm not putting more money into that property. I have to get the trailer that was there cleaned up to collect the rest of the money from the insurance because the township is holding it for a cleanup cost. $12,500.
All right.
And I can't do a thing with the property, and we're talking since the end of February now.
All right.
And I've been waiting for my taxes, and then I've been getting, phone calls from different people because they've been asking to buy the property too, family members. And they said
Well,
that Terry has been running his mouth about me, saying bad things like, oh, he doesn't know how Jessica's going to do this or do that. And I mean, we worked on that house so much. We did so much work on the house. There was even a point where CPS came in and they told us that we couldn't live there because the house was so bad. And that's not from us. That was from when we moved in. And it's like, why can't you work with me, Terry?
Well, it just seems to me like you could come up with a better plan than to buy a burned out house, which is going to cost you another $100,000 to turn into some habitable presence. This is a lease for a tenancy, is a rental. I made a finding that there's that much due and you have 10 days to pay it. If you're not out within 10 days, which you already are because the house is burned up, he can now proceed. The township has got a judgment against him to clean it up. And so it would seem to me you could find a better place to put your money than into the burned out house on Boone Road. All right, I've signed the order. $6,300 due through the end of June. I'm not sure that figure is accurate, but the figure doesn't matter because it's unlikely that she'll pay it. If there becomes an issue regarding money damages, we'll have a separate hearing and figure out how much is what. But I'm not going to order her to pay rent on a burned out house that she's not living in. Here, I'm simply trying to accomplish a possession judgment so the plaintiff can clean up the property, get in compliance with Park Township or Mendon Township. And
I'm sorry.
Okay. And move on. Ms. Burgess, I'm not sure where we've been sending your mail. We've been sending it to that Boone Road address. It says please forward. Would you rather have a different address that I send it?
I've been getting my mail good.
All right, we'll use that
except
address.
for the last court date. The last court date, I didn't get any information on it except for I got it on a Friday and I had court on Monday. And that was due to my landlord's lawyer.
All right, well, you're here now and you've heard everything I said. All right. All right, you're free to go.
Thank you, Your Honor.
All right, thank you.
Thank you.
All right, thank you. Okay, that's a difficult case. I'll leave the live feed up for a few minutes, but we're going to shut the record off. We have several small claims matters beginning at 3 o'clock. All right. We'll just let the blanks, no, I think I'll shut it off. We'll restart it. We had a little trouble with the live chat feature, but we'll be back in a half an hour. No, maybe we'll do a couple polycoms in the meantime. We'll leave it up. All right, we're back. We're going to turn the record on in just a moment. We're going to identify our parties. I've got some criminal cases left over. Good afternoon. This is Judge Middleton here at the court in Centerville. Who am I speaking with?
Hello,
Yes, who am I speaking with?
this is Terry Smith.
All right, Mr. Smith. Stop eating, whatever you're doing. We're going to come to your case here in a moment. Do you have the ability to do video?
I'm not sure that my cell phone service is going to allow it.
All right, well, stay right where you are. I'll be with you in just a moment. I'll put you in the waiting room. Good afternoon. Are you Danielle Ware?
Yes.
This is Judge Middleton. I'm here at the court. Terry Smith is in the waiting room. He's here by telephone only. We have a couple of cases that start at 3 o'clock, and yours is going to take a while. So I'm hopeful to start the other one first, but no one's here on that case yet. So let me bring Mr. Smith back in. It's 2:59. I'm not sure anyone's going to log in on the other case. Mr. Smith, can you hear me?
Yes, sir.
All right, we're going to take this up in just a moment. I guess while we're waiting to see whether anybody else logs in, let me explain how small claims court works. Let me first tell you, we are live on YouTube. This is on the Zoom platform, and it is being recorded. As litigants in small claims court, the rules are different than regular court. They're essentially more relaxed. In small claims court, presently your claim is limited to $6,500. Neither party is allowed to have counsel. Excuse me, I'm trying to suppress a sneeze. You can't have an attorney in small claims court. There's no formal record being made of any of the proceedings in small claims court, and there is no right to appeal. Any decision made in small claims court is final. Either party has the right to ask the court to remove the matter to the general division of the court, where you could sue for up to $25,000. You would have the right to have counsel, you'd have a formal record, and you would have the right to appeal. That's the essence. I'll ask you in a minute if you're ready to proceed. Here's my other party who's a moment late. Good afternoon. Am I speaking with Courtney Shearer?
Yes.
This is Judge Middleton here in Centerville. I need to tell you a couple things. I'll call your case formally. This is file 21578SC. It's entitled Courtney Brookshire versus Kenneth A. Brackett Jr. It is a claim for $4,261. A couple of problems. Mr. Brackett has not been served with this action. And secondly, you can't sue for this kind of case in small claims court. There was a divorce judgment here from St. Joseph County, and that ordered that Mr. Brackett do certain things. You can't do an end around of the divorce judgment in file.
I'm sorry, Judge Middleton. I believe that I'm in the wrong case here.
Mr. Smith, your case is next, so just sit tight.
I'm sorry. Yes, sir. Yes,
You've been sued on a construction contract that she says was very poorly executed. If you had video, you might have a better sense of what I'm doing, but I'm addressing another case. So you just wait a moment and I'll finish with this lady. Ms. Shearer, in file 20002, you got divorced from Kenneth Brackett, and there is a divorce order in effect that orders him to do things. You can't circumvent the circuit court and file an action in small claims court. So apparently you filed this by mail, or the clerks would have told you that you can't do this. Secondly, he hasn't been served. If you're going to sue him, you have to go back to the original divorce court and ask that the divorce judgment be enforced.
Okay.
So I understand you're frustrated about his non-compliance, but
Yeah.
I'm going to dismiss it.
Okay. Yeah, I talked to like the front of the court, and they said there was nothing they could do, and then they actually suggested I take it to small claims court. So
Here in St. Joe County?
Mm-hmm.
All right, I'll follow up on that. You can enforce a divorce judgment in small claims court.
Okay.
Do you know who you talked to at the front of the court?
I'm not sure. This was several months ago.
All right, well, I'm sorry for the bad advice you got. It cost you a filing fee. If you'd come here to the counter like in the old days when we were open, we would have told you you can't do this. Anyway, I'm dismissing this case. And
okay.
All right.
All right.
The friend of the
Thank you for your
court
time.
can't. All right, you can file an action in front of Judge Pattison to enforce it, but not here in small claims court. All right, thank you.
All right, thank you so much.
Okay.
Bye.
All right, we're going to remove that person. All right, now we've kind of cleared the decks for Ware versus Smith. I wish we could see Mr. Smith, but we can't. So I've told you both what the rules are in small claims court. Ms. Ware, are you ready to proceed?
Yes.
Mr. Smith, are you ready to proceed?
Yes, sir.
All right. This is a claim for quite a bit of money, $6,318.45 plus costs, which gets us to $6,399.60. Ms. Ware contends that you were contracted for a bathroom model by referral. Although the work was paid for in full, it was done poorly, improperly, and incomplete. Additionally, it was falsely claimed by the defendant that no permits were needed for the contracted work. Attempt to resolve the matter with the defendant for no avail. So she is suing you for a substantial amount of money, $6,318, just within the jurisdictional limit. She has filed a lengthy document. It starts out background, timeline, and she goes through each of your alleged shortcomings here. There was an original contract that was a quote, which appears to be for $4,584.95. Is that correct, Ms. Ware? Oh, no, that's one of the repair estimates. Let me find the original. Beardsman. I guess there's several. Mr. Smith.
Yes, sir.
Looking for something here. I thought I brought it with me. Are you a licensed residential alteration and maintenance contractor?
No, sir, I am not.
You need a license to do this. In fact, it's a misdemeanor to not, and it limits your ability to represent yourself in a civil action if you're doing work that requires a license without having a license. You got a crappy referral, Ms. Ware. Somebody referred to you a non-licensed contractor to do your work. Having an LLC or a business DBA doesn't give you a license to do this type of work. Give me just a moment. I'm going to quote the statute. Under the Michigan Occupational Code, which is Public Act 299 of 1980, it defines a residential builder. That's someone that builds houses. There's also another category of a residential maintenance and alteration contractor. That means a person for a fixed sum, price, fee, percentage, or other consideration other than wages does any of the following: undertakes with another for the repair, alteration, or addition to, subtraction from, improvement of, wrecking of, or demolition of a residential structure, or building a garage or laying of concrete. Also, probably much of what you're doing required a plumber's license. But anyway, you were engaged as the business of a residential maintenance and alteration contractor without being licensed to do so. And it's actually quite common. So people come in here performing work they're not licensed to do, and they're at a substantial disadvantage when they get sued. Ms. Ware included several dozen photographs, which is difficult to discern without context. I can't see, they're not numbered, so I can't tell what the completed product looked like. There's certainly lots of defects shown, but I don't know what the current status is. So let's start with both of you, please, raising your right hand. You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
I do.
All right, Miss Ware, is this what the bathroom looks like now?
Yes.
Like this photograph, that's what your bathroom looks like?
That's the before.
All right.
Yep.
Well, let me find an after. Because I never thought I saw an after.
It would be like dark blue walls. It's like the after photos.
Here's a picture of some interior wall. Is that what it looks like now? Or is that a before or during?
That was during, that was when he was adding some electric.
Oh boy. here's a picture of through a doorway. It looks like there's a tub enclosure, top of a window, and some blue.
That was almost the very end. That was right before paint was added. And
all right, I think that might be the closest thing I have to an after picture.
sorry, a lot of the after pictures are just up close of like the damage and.
Well, I see a lot of up close pictures of things that don't look good.
That is all the after.
But I don't have an overall view of the space. All right, now let's figure out how much the original contract, the original quote was for. I have something from the Beardsman. For all your service and repair needs. I'm dumbfounded that people are doing this. Every month I get these cases. They don't have an electrician's license. They don't have a plumber's license. They don't have a residential alteration contractor's license. And they don't have insurance. And they're doing this stuff. So the first one is dated 10/12 and it says main bathroom remodel 2195. Is that correct?
Yes.
All right, now the next one is dated 10/13, labor for bathroom remodel. I guess, what is that? What is that one?
I believe that was half
You
of
paid
his,
it. All right, you paid $950.
half of the labor cost before he started.
Well, all right.
About.
Then I have one dated 10/22 and 10/26. So let's look at the 10/26. Is that the final bill?
Yes.
So you paid him $21.95. Is that correct?
Yes.
You paid him $13.75 for labor. And then he's got add-ons, disposal overage $31.26, labor due $4.25. So the total would be $21.95 plus $13.75 plus $456.26, which is $4,026.26. Is that how much you actually paid him?
Yes, and like it says in the timeline, there was other things he had me purchase outside of that. That was the additional costs.
Yes. But what you actually paid to him for what he did was $4,026.26. Then you're asking for some other things that you had to purchase, but you still own those other things.
Yes, and they are in the photos, which I know there's a lot of photos, but they were just damaged in the process of the remodel, so they need replaced. And I think some of it was outlined in the other contractor's estimate of what it would be to repair the current bathroom.
Mr. Smith, what's your response?
Well, I mean, I have a few things. So number one, there are some wrongs that need to be righted, and I accept that 100%. But I was hired knowing that I'm unlicensed. There was no permits to be pulled. So there's also some other line items that were listed that we damaged during the process. In the other quote from the other contractor, there's some things. The Sterling tub, I have the ensemble installation instructions, and it doesn't have to be set in a bed of mortar. I also have statements from master plumbers who took a look at it, said everything is done correctly after there was a valve that we fixed, and all the rest of the plumbing in the entire house was done correctly. So I guess where I stand is we need to figure out what the number is that we can right some of the other wrongs. So, but nothing was installed incorrectly, other than the tub was the wrong size. And we agreed to fix the rest of the plumbing in the house rather than swap the tub. So I'm not sure why that's even in her paperwork, because there was an agreement made, and we took care of that. There were some other things that weren't in the agreement originally that ended up falling on me to do, like the electrical. That was never a plan. All we were supposed to do was change lighting and update a switch, which there wasn't supposed to be any electrical involved in that, so there wouldn't have, that turned into we should rerun all the wires, and at that point I was kind of shoulders deep in it with not very many options. I was also told by Raul Morales on 11/10/20 not to return back to her house, and was instructed to leave at the same time he left.
Who is Raul Morales?
It would be a customer's friend who met me at the job site because she did not want me in her house anymore. And he informed me of that, and instructed me not to return.
But that's incorrect.
That's not incorrect.
When was that?
When?
Yes.
November 10th.
This is so screwed up. You're doing plumbing, you're doing electrical, you got a half-baked proposal here, changes are made, you contend she's having you do non-stuff you didn't have a license for, and she knew you weren't licensed and didn't pull permits. It's pretty fundamental if you're doing this sort of stuff. But I'm not completely clear on when a permit is needed and when it isn't, but I do know you need to be a licensed plumber to do unpermitted plumbing, and you need to be a licensed electrician unless you're the homeowner doing it yourself and charge somebody for it. And there's a lot of uncertainty about what was what. She wants you to pay for everything to essentially tear it out and redo it. And that's where her quotes come from. So, Ms. Ware, is that correct? You want somebody to come in and do it correctly?
Yeah, when I had the estimate done by a licensed contractor, he actually spent a couple hours going through like every detail of the bathroom, and just the condition that it was. He said that's really the only way there is to fix everything is to start over. Like he said, the screws are coming out of the drywall in the ceiling, the floors coming up. Just there was really no way to not have to take right back down to the studs and start over.
The pictures show much of that kind of stuff. The floor looks like it's failing. You put a wooden floor in a bathroom?
It's snap vinyl.
Just a minute. Oh, that's vinyl?
Yes, sir.
Okay, that looks pretty good then. Looks like wood, but it seems to be failing. Um, the anyway, I can't tell what I'm looking at. I see like poorly caulked window sills, paint on stuff, dirty wainscoting and molding. But I don't know at what point in the proceeding it is. I have a bunch of pictures without any context.
Those
I see it.
pictures are all the finished, the ones you're mentioning. That is the finished product.
I see
I
a
have a picture of the bathroom in use with curtain, all of those things in it. Do you also have that picture?
No, I don't know where I would get it. Did you send
Well,
it?
it was sent by her. So,
All right, so it's one of the pictures. I didn't see it.
I guess I'm at home, so if need be, I can walk to the bathroom.
Yeah, that would be helpful. Why don't you go in there and show it to me with your camera?
So the door frame was moved, and this is the like unfinished wall, which is actually framed crooked. The wall is at a curve, I guess you could say. Not sure the best angle, but
All right, now that looks like all right, that's the way the top was left because the molding wasn't finished.
we didn't finish the painting because the drywall just needed completely repaired. So there was really no point. Like this whole side of the tub is patched. Like I said in the timeline, we tried to have a drywall person repair it best they could to see if I could salvage it, but he said the same thing as the contractor, that you basically just need to tear all the walls down and start over.
Could you show me the tub enclosure behind the shower?
Yeah.
All right, and you say it was the wrong size?
So originally it was the wrong bathtub from what we had chosen. But like he said, and it says in the timeline, we agreed to leave the tub since he had already installed it, and he replaced some of the plumbing in the basement to make up for that. But now the issue is that the tub that is installed, I guess it was never protected once it was installed. So I have the brand new tub, being the wrong tub to begin with, is now damaged. And like
damaged how?
There's like like a gash on the inside, and then along the whole
that
outer.
could not have been from anything we did.
All right, just a minute, Mr. Smith. I'll give you a chance.
Yes, sir.
On the whole outer edge, all the finish is completely worn off. That was one of the first things the contractor pointed out. He's like, the finish is entirely rubbed off the tub, and there's gashes in it. And on top of it all, the plumbing still leaks into the basement. And that was after he had come back, and also the plumber had come back himself and tried to repair it.
All right, could you show me the floor?
Sure. Best way to show you, but
show me where the two floors meet. And that's a vinyl product?
yes, that's like a waterproof snap together flooring.
Okay. All right, anything else you want me to see in there?
It's kind of why there's so many like up close pictures, because like the window framing is crooked, the walls where
Show me the window. There are a lot of up close, dirty pictures of that.
it's just everything's just kind of, all the caulk is just dirty, so there's no way to really, but yeah.
All right, show me the bottom corners. All right, thank you.
You're welcome.
All right, you can go back out where you were comfortable. All right, Mr. Smith, what else do you want to tell me?
You know, I mean, like I said, it kind of speaks for itself. There are some wrongs that need to be righted. I don't think that I should pay for another person to come do it, but we need to fix some of the things that I wasn't able to. Like I said, I was told by Raul Morales not to come back to our house. So there was some siding that was picked up and never delivered to her, so I do owe her that. You know, so I'm not in disagreement that some things need to be taken care of. But I think there are some things that are completely wrong, like the tub. There's, like I said, Sterling says it's recommended that if the floor is unlevel, we level the floor before we put the tub in to pour mortar, so that completely needs to be washed out. There's also a line item that says the vanity is scratched. There were no tools of mine put on there. And in fact, Raul Morales was the one doing the electrical. And I do have some pictures of that as well.
Well, it's hard for you to show me
that.
Only by telephone. I'm going to undo this contract. She's asking for $6,318.45. That's to redo it. I'm going to give her what she paid you. 402626. If you keep doing this business without having a license, you're going to lose every lawsuit.
No, I'm done. I'm
right.
done. I
would suggest you get out of the business. A, that looks like very poor workmanship, and B, you didn't have insurance, a license, or a permit.
I did have insurance. Yes, sir.
All right. I'm surprised you could get insurance without a license. 4026.26 plus 8115 equals $4,107.41. I didn't give her the total cost of repair, and I didn't give you exactly what you wanted, but I gave her back whatever she paid you to do without a license.
Yes,
and this is a cautionary tale for her. After she got rid of you, she got some licensed people in there that told her how to do it right. We wouldn't be here if she'd gone to them first, but some guy apparently recommended you, which was not a very good recommendation. Can you make some sort of monthly payment on that?
Yes, sir.
How much can you pay each month?
Can we do 300 to 350?
Yes, I'll do 325. We'll split the difference. Starting July 15th. It'll take a little more than a year to pay it off at that rate, but 325 per month.
And if I decide to, am I allowed to pay more?
Yes, if you want to pay it sooner, if you win the lotto or get it in a stimulus check or something, you can pay it all off. You pay it directly to her. Her address is on there each month by the 15th of each month.
How do I prove that it's paid to her?
I would use a certified check or money order.
Okay.
All right. That concludes this record. I will send you each a copy of that. And thank you.
Thank
Yes,
you.
sir.
All right, we'll stop the live feed.